Good afternoon, ladies and gentlemen. Welcome to our weekly podcast and Merry Christmas. This is a Christmas edition. We are very limited staff today because majority of our team members are already on Christmas vacation. But we cannot afford to waive today's podcast because of the so many updates. As we are already aware, this administration is they are not short of updates on regular basis, so we cannot afford to wait because many of the updates today are completely new. They are different from the update from last week. And for those of you who can see me, I have several pages of updates with me, so it's not something that we can afford to skip. So that's why we have to do it with the very limited team members that we have. Only 2 of us are here, to be precise. But in any case, we have to start. Again, compliment of the season to all our viewers worldwide. Merry Christmas. As usual, we start by talking about the update. And as I said, between last week and now, we have a lot of updates that I'm going to talk about before we go into questions. So the first update I'm going to talk about today is that USCIS clarifies parole fee. You remember that in October, USCIS announced that they will have a special fee for people who are granted parole. I'm not talking of people who are applying for adjustment of status now and they want parole to be able to go in and out. That's not what we are talking about. But for people who are requesting special parole, they introduced the fee then, but it came as part of the big, beautiful bill. So nobody knew how it was going to be implemented until now. So USCIS has clarified that if you need to pay the fee, they are the one that will contact you. So do not pay the fee even if you believe that you need to. They are the one that will send you a letter asking you to pay the fee. So if you are in that category, you have to wait for a letter before you can pay the parole fee that was introduced in October. The second update we want to talk about is that the Department of State announced that consular implementation of the online presence review for H-1B purpose and their dependent, it led to rescheduling of almost all the H-1B visa interview across the world. So it's not peculiar to one country or another, because we will recall that recently the Department of State announced that they are going to be looking into applicants' social media platform, online presence. So whatever you post, in fact, you will be required to provide your is it online handle, they call it? The social media handle, whatever your username, password, all those things, and make it public so that they can access it. So because of all that, they have temporarily suspended interview for H-1B application. So if you have an H-1B application anytime soon, you are probably going to get a rescheduling notice. They are rescheduling people now to spring in order to carry out the online presence review. That is what the Department of State has announced. Again, the third thing we want to talk about today is that the Department of Homeland Security also announced, this is also relating to H-1B visa, they announced that they are now going to be using weighted selection process for H-1B petition. What that means is that they are going to prioritize higher paid beneficiaries. Now, America want to really reestablish the fact that this is a capitalist country. In other words, it's no longer going to be a prevailing wage. It's going to be the higher your employer pays, the higher chances you have of having your H-1B approved. In other words, let's say my law office want to hire a lawyer and we want to file H-1B for a lawyer and we are offering the lawyer $100,000 per year. If another big company also want to hire a lawyer and they decide to offer the lawyer $120,000, what USCIC is saying is that rather than do balloting, they will rather approve the one who is paying 120,000 and deny the one that is paying 100,000. So they are now going to use wage priority. So if you are a company and you intend to hire someone on H-1B, then the higher the salary you offer, the higher the chances of being selected. So they don't want to use just the regular lottery anymore and just pick some random people. No, now they want to use it based on wage. And I also want to tell you, I had this in the news. I have not seen a copy of the decision, but I had in the news that yesterday a federal judge actually dismissed the case that challenged the 100,000 imposition, the $100,000 fee imposed by President Trump on H-1B. Those who challenge it in court, I understand that the federal judge denied that challenge, claiming that the president can impose the 100,000. So the way things are going, H-1B is probably going to become more and more difficult for any employer to scale through, because by the time they pay the 100,000, they still pay the regular filing fee and they are still going to pay the attorney's fees. So at the end of the day, per employee, they are probably going to be spending between 120 and 150,000 per one person. So apparently, this is just this is a policy designed to discourage employers from hiring foreigners. That is the only thing I can see. And now USCIS is saying, DHS is saying that they are now going to use the higher salary. So it's no longer going to be regular balloting. They are not going to be making selection at random. They are now going to be using the salary. So the higher salary you offered, the better the chance of getting approved. That is the third thing. Now, the next update that I want to talk about is that the new USCIS policy memo. There is a new USCIS policy memo, and the new policy memo directs hold and review. I put it in inverted comma. Hold and review of all pending adjustment of status application under DV lottery program. The memo also directs a comprehensive review of the program's policies and procedure. Well, this will not affect Nigeria at all, because Nigeria is not even in the list of countries that are allowed to play the visa lottery at this time. But for countries that are still able to play the visa lottery, this policy will affect them. So the new USCIS policy says that every pending adjustment of status application under the DV lottery, they should be put on hold for further review. So if you have an application that is pending, if you have a green card application that is pending, that is based on DV lottery, so there is a directive that everything should be placed on hold for additional review. And they also want the DHS to also review the program policy and procedure itself. That is the process of playing the DV lottery, the procedure and all of that. They want everything to be reviewed. And for those who already won, they already submitted their application for adjustment, USCIS is saying that everything should be placed on hold right now. That is that. Then the next thing I want to talk about is the updated list of visa-bound countries That is, countries that are required to provide a bond in order to get visa. Those countries have now been updated. So the countries included, based on the recent update this week, those countries are Bhutan. I don't even know which country is that. Is that in Asia? Bhutan, Bhutan. Bhutan, Botswana, Central African Republic, Guinea, Guinea-Bissau, Namibia, Turkmenistan, Mauritania, Sao Tome and Principe, Tanzania, the Gambia, Malawi, Zambia. So those are the countries those are the updated list of visa bond countries that are required to submit a bond before they can get a visa. And the effective date, I need to mention the effective date. So for Bhutan, that effective date is January 1st, 2026. With effect from January 1st, they have to provide bond in order to get a visa. Botswana is also January 1st, 2026. They have to provide a bond in order to get a visa from January 1st. Central African Republic, that's also January 1st. They have to provide a bond in order to get a visa from January 1st. Guinea, that's also January 1st. They have to provide a bond in order to get a visa from January 1st. Guinea-Bissau, also January 1st. Effective January 1st, citizens of Guinea-Bissau will have to provide a bond in order to get a visa. Namibia is also January 1st. In order to get a visa, they will have to provide a bond effective January 2026, January 1st. Turkmenistan, also January 1st, 2026. They have to provide a bond in order to get a visa. Then other countries, those who are already effective. Mauritania was since October. Sao Tome and Principe was since October 2025. Tanzania was since October 2025. Gambia was October 11, 2025. Malawi was since August. Those were the first set of countries. Zambia was since August. So those are the updated list of countries that are required to provide a bond in order to get a visa. Now, I'm going into the major update. This is going to affect a lot of people that I know and people that I also don't know. This is going to be a major transformation of the immigration law in the United States. That is, the next update, USCIS announced an updated policy, according to them, to restore the integrity of VAWA program. USCIS has made a determination that there is a rampant fraud concerning VAWA. In fact, they claim that between the year 2020 and 2024, the overall number of VAWA applications increased by 360%. 360%. They also mentioned that men that were applying for VAWA, the percentage increased by 259%. That is men as filing VAWA. They also mentioned that the percentage of people who were submitting VAWA based on their children or their parents, the percentage increased by 2,239%. Even me, I was shocked when I saw these statistics. 2,239% increase. So USCIS said that this is alarming. It is really, really, in fact, they released a statement that these trends are alarming and unprecedented. So USCIS released a statement that previously the number of VAWA self-petition we receive each year generally grew at a rate similar to other immigration benefits. However, since 2020, we have seen an unprecedented rise in VAWA receipt. And of course, like I said, they released the statistics. So they said that VAWA increased by 360%. Then male applicant increased by 259%. And then male self, in addition to the increase in male self-petitioners cited above, we also saw a 2,239% increase in parents submitting VAWA self-petition between 2000 and 2024. 2,239% increase. That is ridiculous. I was stunned myself. So nobody will see that figure and not expect that there will be changes. So because of that, they have now released a series of changes. The updated policies, one, codify and provide detailed explanation of the provisions of VAWA to USCIS adjudicators. That is, they now told the officers who are adjudicating VAWA petitions what to do, how to look at fraud, how to identify fraud, and they gave them updated instructions. So the instructions, according to USCIS, will streamline the expectation of submitted evidence to reduce the need for RFE and notice of intent to deny. So what that simply means is that now applications can summarily be denied without even asking for request for evidence or issuing notice of intent to deny. So they can summarily deny the VAWA petition once they have evidence of fraud. Yes, that's what that means. The second update. What?
That's against the law. There's case law.
Well,
Okay, I'm sorry.
if you look at these statistics, I don't think anybody can challenge this successfully in court. 2,239% of parents applying for VAWA based on their children. That is ridiculous. That is really, really ridiculous. VAWA was originally meant to be for women victims of abuse. That's why the name is VAWA, violence against women. But because they allow men to also apply, and they also allow parents who are subject to severe abuse by their children to also apply, now everybody is just abusing it. So I really don't blame them for this. So, as I was saying, part of the new policy, they also reinforces the statutory mandate under immigration law that the determination of evidence is credible and what way to give evidence is within the sole discretion of USCIS. So what that means is that the adjudicating officers, they have been given the power, the priority, and the instructions to determine what evidence is credible and what evidence is not credible. So even if you submit something and you want them to attribute weight to it, they can review it, especially after investigation, and determine whether the evidence is credible or not credible. So they are emphasizing this. Then, in addition, they also revised the policy to require that the self-petitioner reside with the abuser during the qualifying relationship. Now, they are going to be conducting more investigation to determine when people are actually living together and when people are not. Generally, if you are not living with somebody, that person will not be able to have the opportunity to abuse you. So living together is going to be a major determination going forward. That is what that simply means. Then the next policy adjustment is that they will now require self-petitioners to establish that they enter into the marriage in good faith with the alleged abuser, providing evidence of marital relationship. Of course, that has always been the law. It's just that they are re-emphasizing it. They are re-emphasizing it that an applicant now, before they can get VAWA, they will have to now show that they enter into marriage in good faith. Before, so many things are waived for VAWA applicants because of the belief that it is possible for somebody who is being abused not to have access to certain documentations. So they take all that into consideration. But because of the alleged fraud that they have uncovered now, the large number of fraud, so definitely all those things are going to affect innocent people, unfortunately. The next adjustment, according to the policy, is that USCIS will require a self-petitioner to establish he or she enter the marriage in good faith. Okay, I think I just mentioned that. No. This one is different. Okay. It requires a self-petitioner to establish he or she enter into a marriage in good faith with the alleged abuser by providing primary evidence of the marital relationship, including but not limited to a legally valid marriage certificate, proof of the termination of all prior marriages, and bona fide evidence of relationship. I can tell you for free that based on my own experience, there were lot of fraudulent divorce decrees that people were using to apply for VAWA. And they are saying now they are going to be going after all those things. So, my listeners, please, I will advise you, if you are here, it's better to do your divorce here. The days of going back to backdate some documents, some fraudulent divorce decree, all those days are gone. Especially now with the level of fraud that USCIS has uncovered. Even now, a lot of innocent people are going to be affected. Because when things like this happen, sometimes it is difficult to distinguish somebody who is a real victim from somebody who is just claiming to be a victim or pretending to be a victim. Now, the policy also highlights the requirement of initial evidence and provide clearer explanation of the any credible evidence provision. Again, like I said, technically, all the lapses that were allowed under VAWA, they are removing them. That's what this policy simply means. All the lapses that were given to people that were abused, but because of all the abuses, they are taking away all these lapses. Because normally, evidences that you present to USCIS when a US citizen petitioned for you, and USCIS will say this evidence is not enough. Normally, if you present the same evidence to VAWA, they will approve the VAWA, because VAWA all used to take into consideration the fact that, well, this person has been abused. Maybe this person does not have access to this information. Maybe this person was not able to get the document because the abuser will not allow him or her to get it. All these things. But all those lapses, this new policy, they are taking the lapses away. So now, question of any credible evidence is no longer going to be accepted. You now have to provide substantial evidence of your relationship. Now, USCIS is also, the policy also corrects some terminologies in the update. Some of the terminology has to do with, for example, they removed the term polygamy from the discussion of intended spouses, and they now use the word bigamy. And let me tell you the implication of this. They are laying the foundation to be able to prosecute people for criminal offenses. Because now, once they change the language to bigamy, whenever they are able to prove that a divorce document was not valid, it means that that person has committed bigamy. So that is the foundation they are laying here. So that is why people need to be more careful in submitting fake divorce documents now, because they are removing the previous word, which was polygamy. They are changing it with the word bigamy. I mean, it may look minor, but from the legal standpoint, I can tell you the big difference. I mean, to the best of my knowledge, polygamy is not really, there is no statute that criminalizes polygamy. But there are several specific statutes that criminalizes bigamy. So that's why they are changing the word. They are using the right word now so that they will have the opportunity to go after people who committed bigamy. Because now, if you are married to more than one person at the same time, meaning that if a previous divorce was not properly terminated, you have now committed bigamy. So they are making all these adjustments to be able to go after people. Now, they also clarify that, of course, we already know that, but they are just clarifying it, that people who got married while already in removal proceedings, that they will not be eligible for VAWA. They are clarifying that. Yes, that's why normally when people get married while in removal proceedings, we always submit 2G exemption letter. So that has always been the law, yes. But they are just re-emphasizing it here. So if you are already in removal proceedings before you get married, you may not be eligible for VAWA except you meet the exception, which, of course, under this new policy is going to be more difficult. The next highlight on the policy, USCIS clarifies that battery and extreme cruelty and good moral character requirement during VAWA self-petition. Yes, they also clarify the use of the word battery and extreme cruelty. So you now have to be, well, for somebody like me, I've always known the difference between all these things, because so many people have been to my office, and when they present that their VAWA statement, I will tell them that all these things you stated here, they are not eligible for VAWA. I mean, example, my wife is cheating on me. So what? That's not a requirement. That's not eligibility for VAWA. If your wife is cheating on you, you don't like it, that's why there is divorce court. That's not abuse. I mean, my wife smokes marijuana or smokes something. So what? Is her life, is his life. That's not abuse. Those are not abuse. But people don't get all these things. But now USCIS is re-emphasizing it, and because they really want to separate people who are real victims for people who are just using VAWA to get green card. That is what they are saying here. The next thing the policy mentioned is that the policy also amend the previous policy on the termination of a step relationship when either the biological or legal parent of the child dies, by requiring the self-petitioner to provide evidence that the relationship with the surviving abusive parent or child continue after filing. Again, this has to do with those who are petitioning based on children and step-child relationship. So what they are saying is that it is not enough to just say that the abusive person is dead. No, you have to provide evidence that even after you submitted your application, you still have that stepchild relationship with the dead person. So that is what that was saying. Additionally, this policy elaborates on how USCIS consider information related to an alien's good moral character. We also know that for VAWA, good moral character is a requirement, but previously, good moral character simply means that you don't have criminal record. But as we already know with the case of citizenship, they are saying that good moral character will go beyond somebody not having criminal record. It will go beyond other things. Apart from you not having criminal record, what have you done for your community? What role have you played since you entered the United States? So good moral character is no longer just going to be because you don't have criminal record. Even for VAWA purpose, you have to show all those new evidence of good moral character under the new policy, the same policy as citizenship. And this policy also stated that that USCIS is going to be using case by case basis as the standard when they are determining good moral character. It is going to be on a case by case basis when it comes to good moral character. Well, that is the policy, that is the update as it affects VAWA. I have one more update before we go. I know that time is fast spent, but we will try as much as possible to answer most of the questions today. But these updates are also important. It is important that we state it. So the last update I want to talk about today, which is still the effect, or is still a continuation of the VAWA update. USCIS is now saying that the protections that were granted to VAWA applicant, this is crucial. That's why I made it the last point. The protections that were granted to VAWA applicant. You know that normally VAWA applicants, they have this confidentiality. The confidentiality is so much that even other USCIS officers, they don't have access to VAWA files. It is only the VAWA office that can have access, which is why in the case of VAWA, it is difficult to communicate with them over the phone because those officers who will answer the phone, they don't have access to the VAWA. But USCIS is now saying that all those protection, the confidentiality protection, that they will all end at naturalization. So what that means is that for VAWA purpose, yes, they will still grant you the protection. Your case will still be treated with confidence. However, at naturalization, they are going to unveil all these things. So now, officers will be able to access information that they were not able to access before you about you before. So what I see here, if this policy is implemented, and of course is already into effect, we are probably going to be seeing cases of people being denaturalized. Because what this simply says is that if you have gotten your green card through VAWA, now because the protection, the confidentiality protection will no longer be there, they can now revisit your story. They can now revisit your evidence. So technically, this is more like an audit of VAWAs that have been granted. That is what this word is saying. So they are now saying that the protections that were previously granted, which means that abusers cannot access immigration record, which means that USCIS, ICE, and DHS do not disclose information that could endanger the victim of VAWA, which means that immigration enforcement cannot rely on information provided by the abuser, which means that all these protections that were initially granted, they are saying that these protections are going to end at naturalization. So these protections will no longer be there. So it means that at naturalization, they can now talk to the abuser. At naturalization, USCIS and DHS can now disclose information that they believe could even information that could endanger the victim. So all this protection ends at naturalization. This is what this new policy says. As I stated at the beginning, in view of the number of fraud that they announced, I don't see how anybody can challenge this policy successfully in court. I think this is a policy that is going to stay because of the. I didn't even know. In fact, in my practice, I don't think I've ever filed VAWA. I don't think I've filed more than 2 or 3 VAWA cases for parents using the children as. Yeah, one recently. In my entire practice, I don't think I've done more than 2 or 3. So to now see that this thing increased by 2,239%, that is insane. That is insane. Even for men, almost more men now apply for VAWA, almost the same number as women. That's unheard of. Anyway, let's go into questions for the day. Again, our listeners, Merry Christmas. Let's start. Is that the first question? Okay. The very first question for the day. Happy holidays to you and your team, sir. Yeah, happy holiday. Thank you. Please, sir, is domestic travel safe now as a Nigerian with a 3 prima facie EAD and real ID? Please advise. Thank you. Number 2, what's next after receiving 3 prima facie? Well, yeah, if you have a prima facie and you have a valid real ID compliant driver license, yes, you can travel safely within the country. That is very correct. Well, what is next after receiving prima facie? Usually, they will adjudicate your case, and if it is approvable, they will go ahead and approve it. If they have request for additional evidence, they can issue request for additional evidence. If they have, if they see something why they believe it should be denied, they will issue notice of intent to deny. However, based on the policy that I just read today, it is possible that they may not issue any notice of intent to deny now. It is also possible that, but I want to assume that they will still do, because since people apply under the existing policy, I don't think they will punish anyone who apply under the previous policy. Well, that is just my own opinion, but we don't know how this policy will affect existing applications. But what I do know is that this new policy, they are telling the adjudicators to what to look for now. And remember, was it last week or 2 weeks ago that I mentioned that the Department of Homeland Security just created a specialized office that is going to be monitoring fraudulent immigration filing, that their headquarters is in Atlanta, Georgia. So with all these resources and with all this fraud coming up here and there, definitely it's not going to be a smooth sailing for VAWA applicants going forward. But I just wish you good luck. Hopefully, your case will scale through. But the next thing you expect is just a decision or a request for evidence if something is required. Okay, next question. Compliment of the season. Thanks for all you do. Happy New Year in advance. I wish you the same. Thank you so much. Next one, Merry Christmas, Dr. Asekun and team. Your podcast saved a lot of us from error this year. God bless you, sir. Amen. Kindly clarify the misrepresentation in most news outlets that green card has been suspended. Well, that is a very good point, because after our last podcast, despite the clarification that we did, a lot of people kept sending all kinds of misinformation. Let me say this. It is not everything you see on social media that is accurate. Some people are intentionally creating a sensation so as to attract people to their pages. So it is not everything that is accurate. Anybody who tells you that green card application has been suspended is not telling you the truth. I can tell you that in this office, in our own office here, we still got green card approved this week. We got green card approved last week. So anybody who tells you they are not adjudicating, they are telling you something that is a complete lie or misrepresentation. However, if you listen to the podcast, the update earlier today, I did mention there are some specific cases that are paused, especially for people who apply for green card under the DV lottery program. Yes, those ones are being held for now for additional review. But general green card, is it being paused? No. Employment-based green card, is it being paused? No. Family-based green card, is it being paused? No. All those things are not true. Now, when it comes to the visa ban countries that we announced last week, anyone who is applying for visa at the U.S. Embassy in any of the countries that were listed, either banned wholly or partially banned, yes, immigrant visa applicants will also be affected. Those are people applying for visa out of the United States, effective from January 2026. That may be true. But those who are already in the United States and who are applying for green card in the United States, was it paused? No, there is no such thing. And I also want to tell you, even for those who are applying for visa abroad, if your application has not gotten to the embassy inviting you for interview, if you have not gotten to that stage, continue to process your application, because this policy, according to this policy, they will review the visa ban every 180 days, every 6 months. So if you stop the process now, if they review it in 180 days time and then your country is lifted from that list, is it then that you are now going to start? No, continue with your process. But green card application process in the United States has not stopped. In this office, we continue to represent people, we continue to submit new applications, we continue to attend interviews, and we continue to get approvals. And like I said, since this rumor started, we have gotten green card approved in this office. So those things are not true. Next question, please. Compliment to you and the team. Thank you too. As a valid H-1B holder, will I need to return to the US before the new year to avoid the entry ban? No. If you already have your visa, it does not affect you. I repeat it. It is only people who are going to the embassy to apply for visa. If you already have your visa, it does not affect you, except if your visa is revoked. That is also a possibility. I've seen a couple of H-1B visa holders who received an email telling them that the visa has been revoked. For people like that, yes, can they travel? No. They will no longer be travel because of the revocation of the visa. Because as soon as that visa is revoked, the U.S. Embassy will have notified the carriers, the airlines. So when you get to the airport, if your visa has been revoked, the airline may not carry you and bring you to the United States. But for the purpose of people who already have a valid visa, it does not affect people who already have visas, except those visas were revoked. But let me tell you this. If I am the one that have H-1B at this time, in view of all the changes that are going on with H-1B, if I'm outside the country, I will come in right away. That is me. There is no policy that says that. It is just my opinion based on all the changes going on now. And I just explained today that even those who went to court to challenge the president for imposing $100,000 fee on H-1B, the court said no, the president has the authority to do that. So that will also embolden this administration. So they may come up with additional review regarding H-1B. As I stated before, the issue of online presence is also being implemented. Social media posts of all applicants for H-1B. So, but because you already have your visa, those things may not affect you. But you don't know what they can. I don't know what they can find on your online platform. What if they find something and then they revoke your H-1B visa? Coming back in may be difficult, because if you are in the US, even if they revoke your visa, you may still quickly do something about it. But if you are out of the US, if your visa is revoked, that's it. You will not be able to come back into the country. That is why I said, if I am outside now, I would rather come back in. Next question, please. Compliments to you and your team, sir. God bless you richly. Amen. And you too. Happy winter break. Thank you. Next one. Will I need to use my Nigerian passport and my letter of green card extension at the Nigerian airport to come back to the US? Oh, yes. Oh, yes. No. You need your Nigerian passport, you need your expired green card, and the letter. The letter itself will not bring you back. The letter plus the green card that expired. So you need three things. Your Nigerian passport, your green card, the one that expired, and the extension letter, original of the extension letter. Most airlines will not accept photocopy. The original extension letter, your green card that expired, and your passport. Those are the three things you need. Next question. Merry Christmas, sir. Thank you so much for all you do. Do it yourself. Okay. For all I'll do it yourself team. Okay, you're welcome. You're welcome. Thank you. Thank you. Compliment of the season, sir. Thank you for all you do. Thank you. Compliment of the season too. Okay, next question. As adjustment of status family petitioning stopped because of partial ban and from partial ban country? No, it has not stopped. If you are in the US, adjustment of status has not stopped. But if your case is consular processing and your case has gotten to the embassy stage for interview, yes, it is paused for now because of the travel ban. But only for people applying for visa. If you are in the US and you are applying for adjustment of status, it has not stopped. Next question. Can I add second joint sponsor if my first sponsor wants to use bank statement to supplement tax return income? They will not even accept a bank statement as a supplement. No, they will not accept that. They will accept tax return or evidence of asset. Maybe you have 401k, maybe you have a house. They accept asset. Because bank statement, what if somebody just borrow money, put into your account and you submit it, and then you go back and withdraw your money? No, they don't accept things like that. They accept asset. But asset, maybe stock, if you have stock holdings, you have investments, you have 401k, IRA, properties, rental properties, all those things they accept. Generally, they accept asset if the income is not enough. But normally, it is tax return. But can you use a second joint sponsor? Yes, you can. You can also replace the initial joint sponsor and introduce a brand new sponsor. Yes, all that are possible. Next question. Is it not the same question?
It's the one above it.
Oh, okay. Okay. Good afternoon, sir. Can a 2-year green card holder file for a mom? No, sir. Even if you have 10-year green card, you cannot file for mom. That's one of the differences between a U.S. citizen and a permanent resident. A permanent resident cannot petition for parents. A permanent resident cannot petition for siblings, brothers and sisters. A permanent resident cannot petition for married children. A permanent resident cannot petition for fiancé. All these things are the exclusive right of U.S. citizens. It is one of those major differences. A permanent resident cannot petition for somebody who is out of status. Only US citizen can do all of that. So you cannot petition for your mom until you become a US citizen. Next question. 180 days limit is it? Okay, Merry Christmas. Yeah, thank you. 180 days limit now reduced to 90 days outside the country. Kindly confirm, sir. May God bless you and your team. Merry Christmas. Merry Christmas. This is one of those fake news. There's no such thing. I've had it myself several times. Last week I even had to contact AILA, American Immigration Lawyers Association. That maybe there is something that I missed. There is no such thing. All those things are fake news. Somebody even said that the 180 days reduced to 90 days was effective December 26th. There is no such thing. The only thing that is coming into effect on December 26th is the exit and entry and exit inspection. That is the only thing that is coming into effect on December 26th. So those things are not accurate. It is not true. Next question. Compliment of the season. Just a quick question.
Okay. Oh, I found it. It's all the way down here. Are Nigerians holding a green card currently and who want to naturalize affected by the ban? Here, let me see if I can find it on here.
Even without looking at the question, I've answered the question already. The ban does not affect anybody in the United States. If you are in the United States, it does not matter whether it is total ban or partial ban. The ban only affects people who are applying for visas abroad, not somebody who is physically present in the United States. So the ban does not affect naturalization of people in the United States. Next question, please. Please, sir, is the approval of EAD for asylum seeker also suspended for extra 20 countries added? I believe this person is talking about the visa ban countries. Yeah, again, it does not affect people who are in the United States. So if you are in the United States and you have your application pending, this travel ban does not affect you. You can continue to apply for your employment authorization card, EAD. You can continue to apply for it. It does not affect your ability to do so. Only people who are in the United States, who are outside of the United States, who are applying for visa, they are the people that are affected. Next question. Hi, doctor. Well done for the good job you are doing. Thank you. I have US passport and presently in Nigeria for vacation. Could this travel ban affect me while coming back to? Oh my God. You see, if a US citizen can be afraid, you can see. I'm not really surprised because I've seen all kind of things on social media that could be scary. In fact, one of my colleagues, who is also a lawyer in Dallas here, who is currently in Nigeria as well, he posted something hilarious on our association's WhatsApp page. Another Nigerian was concerned for him that, with all this travel ban, how are you and your wife, how are you going to get back to the US? He now told them that, well, it means that I will retire early. My brother, my sister, it doesn't affect Americans. It doesn't even affect green card holders. It doesn't even affect visitors who have a valid visa. It is only people who are applying for visa. Those are the people that were affected. You know what? Maybe, let me see if I still have the exception.
Did I take it out? I don't know if I put it back.
Okay.
Do you want me to go get it?
No, don't worry. I was just going to quickly go over the exceptions for them to know who is affected and who is not. Since only you and I are here today, if you get up, that will affect, that will disrupt what we are doing. So, okay. Maybe at the end of the podcast, if we have time, we can still quickly run through the exception. But It doesn't affect Americans. It does not affect you. Next question. Sir, my daughter is waiting for her green card as SIJ petitioner. She just turned 17. I'm also waiting for my VAWA, which I petitioned this August. Please, should I leave her in SIJ or add her to my VAWA? Well, this is a very difficult question to answer because number one, I don't know how strong your VAWA case is. And with all this policy review that I mentioned today, considering the extent of the fraud that was uncovered in this VAWA case, it is going to be extremely difficult for me without knowing how strong your VAWA case is to advise you whether to add your daughter to it or not. I will suggest that you leave your daughter in the SID except if you feel that one is also not very strong. But it's not something that I can tell you do or don't do without knowing how strong your VAWA case is, especially in view of the information that was provided today regarding the VAWA update. Next question. Hello, attorney. Wonderful to see you on this Christmas Eve. Thank you so much. Blessings to your family. Thank you. Merry Christmas as well. My country is on a partial ban. With the new pause, does it mean I cannot renew 10-year green card? Again, I think I've answered this question. It does not affect you. It only affects people who are applying for visa. If you are outside the United States and you are applying for visa, you are the one that is affected. You are the one that is affected. Next question, please.
Sorry, there were some people saying that they couldn't hear you.
Oh, okay.
Yeah, I just wanted to be sure. I mean, I checked on mine and...
Is there a lot of people? Is there... I think people are hearing. I mean, people are sending questions.
Just, yeah, somebody had called and said that there was a whole group chat of people saying that they couldn't hear you. But
Okay.
I'm checking.
Okay, just move to the next question while I answer that, then you can check. But I think at least I can hear myself, so I don't think we have any audio issue. I can hear myself clearly. And normally, from experience, if people cannot reach us, they will have commented that we can't hear you, we can't hear you.
Yeah,
So
you ask people if they can hear us?
well, if you're online and you have issue hearing us clearly, you can just text for us to know. But to the best of my knowledge, everything seems to be okay. I can hear myself, so I don't see any issue.
Yeah, I put
So
on
it may be audio from those people's end. So
maybe. Because, yeah, I can hear you.
okay. Now next question. Okay, thank you and your team for all you do. Please, can someone go ahead with application for EB1 and green card? If you are in the United States, yes, you can do so. But if you are outside the country and you need to apply for visa, if you are from a visa ban country, you will be affected. But if you are in the United States, the visa ban does not affect you. This is one thing, those who are still thinking about asking those questions, I want to say this because at the end of the day, we may end up not answering, we may not be able to answer everybody's question. But if your question relates to this, I want to tell you, look at the word visa ban. We are talking about visa. I've explained it before on this podcast. Visa is different from I-94. Visa is different from legal status in the U.S. Visa is a document that is issued by the U.S. embassies and directed to airline to allow the airline to bring you to the United States. As soon as you enter the United States and you stop at the airport, you come out of the plane, visa's job is over. From that moment, you are now, when you get to the line, when you get to the CBP line, that is where you are applying for admission. Like any admission, your admission could be granted, it could also be denied. So visa's role ends at that moment. How long you stay in the United States How long you remain legal in the United States, that is determined by the CBP officer. If you are coming with visitor's visa, the CBP officer can give you 2 months, can give you 3 months, can give you 6 months. So it is whatever they give you, that is what determines your status, not your visa. Your visa does not determine your status. So when we are talking about visa ban, it is the visa that we are talking about. We are not talking about green card ban. No. It only affects people that are going to the embassy to apply for visa. Even people who already have their visa, they are not affected. I think you may need to bring the exception. Let me go over the exceptions again. But pose the next question before you leave. Sorry, we are operating with limited staff today. I mean, we are already on vacation. Many of our team members are already on Christmas break. So it's only 2 of us here today. So just bear with us if we are having some breaks. While waiting for that, let me quickly go over the next question. The next question. Hello, doctor. Thank you for all you do. You're welcome. Please, is H visa exempted from the Nigerian visa ban? Can one with H1B and H4 visa travel and return to the US next year? Well, again, I just explained. If you already have your visa, you are not affected. If you are still going to the embassy to apply for visa, you are affected. However, because this question is talking about H1B, I want to say that for H1B, there is a lot of review currently going on. One of the review is what is called online presence review. They are looking at social media posts of all applicants and their dependents. So if you know, I mean, you will know yourself more than I do. If you know that they may find something on your social media platform, your H1B may be revoked for that reason. It may be revoked for that reason. If they can find your something negative, maybe you have commented about one policy, about the US government and all of that. I tell people that if you are going to criticize the president, make sure you are a US citizen. If you are not, anything you post online, they can use it against you. They can use it against you later, whatever you post online. So if you are going to criticize the American policy and all of that, and you are not a citizen, all those things can work against you. So if you know that your online presence may endanger your H1B, then I will advise you not to travel. There is really no policy against it. This is just my personal advice based on what is currently going on regarding H1B. And especially with the recent decision from the federal court yesterday granting the president the power to continue to impose the 100,000 that he wanted to impose on H1B. But are you affected by the ban? The answer is no. Please move the next question. Okay. Next question. Merry Christmas, sir. Merry Christmas to you. My husband is a green card holder. He filed I-130 for me and my kids from Cameroon on the 21st of April 2023. No approval yet. Is there any possibility that something is wrong? Well, the fact that there is no approval does not necessarily mean that anything is wrong. First thing I want to tell you is that there are multiple regional centers processing this type of petition. Some of them, their processing time varies. Even if you are a US citizen, if your case is somehow allocated to the National Benefit Center, that office, I don't know what they do there, but they are extremely slow. I-130 petition in that office is taking 4 years, and the last time we checked, I think it was 50 months. The last time we checked. So that is 4 years and 2 months. So if your petition gets into that kind of office, you know that there is going to be substantial delay. So it does not necessarily mean that there is anything wrong with your petition. Because if this was filed in April 2023 and your case was assigned to that kind of regional center, then it's going to be delayed. So it doesn't necessarily mean that something was wrong. Can you please move it forward? Okay.
I think this was in regards to your updates about H1B.
He said this is not accurate. The H1B waited. What is not accurate? That was part of the.
I know that.
That was part of the policy.
Hold on.
Is that additional
Yeah,
information?
the higher wage will be placed in more times than overwage.
Well, let me go over that policy. The policy says that DHS announced a final rule establishing a weighted selection process for cap subject H1B petition that prioritizes higher paid beneficiaries effective February 27, 2026. The rule will apply to the fiscal year 2027, which of course that is the one that is starting in February next year, in 2 months' time. So what is that is not accurate? I'm not the one that made the policy. That is what USCIS has announced. They are going to be using salary. It is going to be wage they are now going to be using in order to determine who to allow to file H1B. It's no longer going to be based on the lottery as they used to do. That is what was announced. It's not my making. That is what the policy says. Can you please go to the next question?
Yes.
Okay. Please answer my question today, sir. Okay. Good day, doctor. Thank you and your team for the great job. I and my family, we have asylum pending since 2019, but we were granted immigration judge this year. What do you mean by granted immigration? Or does it mean that it was referred to the immigration judge? Is that a follow-up? What is the question?
Please answer my question. My family. Okay.
Okay, maybe there are questions. I see one. Okay.
One in March.
In March, we plan to apply for travel permit for our vacation to Europe. Do we need biometric fingerprinting and medical tests before we can travel? Because we already did one before in 2019. Please, the next question. Move to the next question.
Please advise.
Us the best way. But scroll down a bit. I will say this. Whoever asked this question, I want you to clarify, because this question is not clear. He said you are granted by immigration. Okay, hold on.
Yeah.
We have asylum pending since 2019, but we were granted by immigration judge this year. Okay. The asylum was granted by immigration judge.
Yes,
okay. It's very clear now. It's very clear. Okay, so now they want to know, we plan to travel. We want to apply for travel permit for our vacation to Europe. Do we need biometric fingerprint and medical tests before we can travel? Well, you need to apply and obtain travel permit before you can travel, because for travel permit, for asylum, for people who have been granted asylum, you will be given a passport by DHS. I think we just received one yesterday. Can you quickly see if you can get it? Let me show it to people what it looks like. You will be granted a passport by DHS. So it is that passport that you use to travel. And of course, once you submit your application, you will be requested to take a biometrics. Yes, it's a mandatory requirement, even though sometimes they can waive it, and USCIS can waive it if they have a recent biometrics for you. Let me show you a copy of this is what the passport look like. You see, this is what the passport look like. So they will grant you a passport. If you are granted asylum, this is the kind of passport that the United States Department of Homeland Security will grant you. Can you get it closer to the camera so that they can see what is written there? I think it is a travel document issued by US Citizenship and Immigration Services. Yeah. So that is what you need in order to travel if you are granted asylum. And of course, your question is whether you need biometric. Yes, you need biometric, but you don't need medical test. You only need biometrics. So once you apply, they will send you a letter asking you to go for biometrics. And then once you do it, they will issue this passport. Remember, if you are granted asylum, you can no longer travel with your home country's passport. This is what you need to travel. So that is very important. Very, very important. If you don't have this, if you travel, you may not be able to come back in because you cannot travel with your home country's passport. You need this passport to be issued to you by the United States Citizenship and Immigration Services before you can travel. Thank you, Kim. Next question, please. Okay. Please, sir, can I go ahead with my N400 application as a Nigerian with green card and eligible? No criminal record, no arrest, but 3 speed citation 2017, 2019. Should I state this in my application? Oh, yes, you can go ahead. There is nothing stopping anybody from applying. Like I said, we continue to apply for people. They have not paused any application. All those things that are going on social media, many of them are not accurate. Some of them are intentionally providing sensational news so as to attract viewers to their homepage. Many of them are not accurate. So you can go ahead and apply. Having a citation is not an issue. I can assure you that probably the officer that will interview you has also received citation. I have also received citation. Citation is not a big deal. Everybody gets it. For as long as you don't allow it to lead to warrant of arrest. Because if you get a citation and you don't take care of it, if it becomes a warrant of arrest, once you are arrested, that arrest record is going to be showing up in your record. Even though it does not disqualify you from citizenship, but it's better to not have any arrest record at all than to have one and have to start explaining. So that is why I said that is not an issue. Okay. Next question. Nigerian hobby F1 and wife F2 apply for change of status to LPR. PD priority date October 12, 2025. Again, priority date is not applicable to, it's applicable to immigrant petition, LPR. USCIS child file for parent. Progress on my USCIS is decision stage and interview waived. Should hobby apply for OPT PhD ended December 2025? Well, if USCIS child already, if USC child already apply for them and that application includes employment authorization, OPT may not be necessary. But if the application does not include employment authorization, I would suggest that you go ahead and apply for OPT. That would be my suggestion. And since they said this person a PhD ended December 2025, to the best of my knowledge, you have to apply for OPT before the end of the program, not after. So if you are going to, if you are going to apply for OPT, you have to do it right away if your program is ending this December. I know it's a requirement. You have to apply for OPT before the end of the program, not after the program. But if EAD was submitted along with the adjustment application, then OPT is not necessary. Thank you. Next question. USCIS asked memo saying applicant country of concern is a significant negative factor. Do you think USCIS will issue RFE asking people from banned countries to submit positive discretionary factors? No. That one affects people who are applying for visa. People who are applying for visa. It doesn't affect people who are present in the United States. In fact, people who are applying for asylum, if they designate your country a country of concern, it will actually give your application more credibility, more strength, more weight, because you are saying that, you see, even if American government know that there's a cause for concern in my country, if I go back to that country, I will not be safe. Yeah, it doesn't affect any application here. Next question, please. Did you not just jump one now?
No, we answered that one.
Oh, we
That
answered.
was the one that was, there was more of it before.
Oh, okay. Hello, sir. I got granted mine with. That thing is moving forward. Can you please?
Sorry.
Yeah. Hello, sir. I got granted mine with. Oh, my withholding of removal in 2023, and I have an ICE check in January. What are the chances I get detained? No, you can't get detained. Withholding of removal is a relief. You cannot get detained. Even if the government believe that there is a change circumstances in your country, they will need to first file a motion to reopen and ask the immigration judge to reopen the case before they can do anything. You cannot get detained. Next question. I have a current visa, IR2 visa, that will expire in April 2026. I have bought ticket to fly to the US on 24 January 2025. I hope this new immigration law won't affect me on my visa. I want to believe this person meant 2026 because
Oh, yeah, I think so.
because 24 January was a year ago. So that's not in the future. So 2026. Yes, does the new law affect you? No. The ban, no, it does not affect you. Because you already have your visa, it doesn't affect you.
Oh, they sent it a few times. Oh, look at that one.
Thank you for all you do for mankind. Thank you. Thank you.
Oh, this is a part 2 to the OPT one.
Okay, the OPT asking because of the partial ban, or will OPT be better? Is OPT subject to ban too? No. I'm sure this person posted the question before I clarify the ban issue. The ban only affects people who are applying for visa outside of the US, not people who are applying for green card in the US. Excuse me. Good evening, sir. How about people that need to go back to Nigeria and renew their student visa? Yes, they are affected. If you need to go back to Nigeria to renew your visa, don't go. Let me say this. If you are on student visa, if you are on student status, for as long as you are in school in the US, your visa, the expiration of your visa does not affect your status. That's why on your I-94 they write DS, duration of status. So don't panic. There is no cause for concern. Continue your education. The only thing you cannot do for now is to go back home. But you are maintaining, for as long as you maintain your legal status here in the US, you are okay, even with the expiration of your visa. But if you go home, will you be able to renew your visa? No, you will not, because these are the specific people that were affected. I remember the policy specifically mentioned B1, B2, F1, F2, M1, and what other, and J, yeah. B status, F status, M status, and J status. They were specifically mentioned. Will you be able to renew your student visa? The answer is no, you will not. These are the category of people that were specifically affected. Next question. Good afternoon, Dr. Asekun. A big thank you to you and your team for all you do. You're welcome. Thank you too. God bless you and all, and Merry Christmas to you and yours. Amen. Merry Christmas. Thank you. Thank you. Okay. How are you, sir? That's the next question. How are you, sir? God bless you for your services. What would be your advice for a spousal non-immigrant visa that was denied based on 221G of the INA? Also, the American spouse died after putting in
After putting in the application.
the application, and the other non-American spouse was deemed documentarily qualified, and he got a co-sponsor after the demise of the American spouse. It was IR. In interview, no,
It was IR and interview was waived.
an interview waived was noted. No, you are reading. That's a different question.
No? That's this person, yeah. The application and the other non-American spouse was deemed documentarily qualified. He got a co-sponsor after the demise of the American spouse. It was IR and interview waive was noted on the online profile.
Well, the reason interview will be waived was because the moment the petitioner died, there is a presumption that the application itself is dead. Now, you will need to request humanitarian consideration for somebody else to take over. But in a spousal relationship, I don't even know who can take over, because usually the ones we have been able to do successfully are where the petitioner is a parent. If one where multiple the parent, maybe the father and the mother, both of them are either US citizen or permanent resident, one petition for the child, and then while the application was ongoing, the one who petitioned died, then we can request humanitarian consideration, and we switch the petitioner from the one who died to the other parent. But in the case of a spouse, I don't see who is going to take over, except if they have an adult child who is a US citizen. So I don't see how this person can get the visa. So they are going to return the package to USCIS, and of course USCIS is going to the petitioner is even late. What I will advise in this case is that, I don't know if a lawyer is involved. If a lawyer is involved, your lawyer should request the embassy. If the case is already at the embassy is going to return the file. Once the file is returned, your lawyer should request that the petition should be converted to a widow or widower's petition. So that way they will be able to continue processing the application. But generally, once the petitioner is dead, especially in a consular case, once the petitioner is dead, the application is dead. There is a presumption that the application is dead. However, the presumption is a rebuttable presumption. In the case of a spouse, the petition can be converted to a widow or a widower's petition. But if it is a case of a parent-child, then you can request humanitarian consideration that the petition be taken over by another family member who have the same immigrant status as the one who passed. So that would be the only concern I see from this question. If the interview was previously denied, let me see. If the interview was previously denied based on 221G, 221G means that they don't have enough evidence of the relationship. So if they already denied it because they don't have evidence of the relationship, so even if they change it to a widow or widower petition, you will still face that challenge. Except if you have the evidence, maybe it was not properly presented before, you can repackage it and represent it. But if there is not enough evidence of the relationship, then I don't see a widower petition being successful. But at least you stand a chance of requesting the case to be converted to a widow or widower's petition. Next question, please. Thanks for all you do, sir. What about those already scheduled for visa F2 interview in January? What do you suggest is done because the recent update from the embassy wasn't clear on it? Yeah, if the update from the embassy is not clear, I believe our own update here is very clear. Yes, you will be affected. These are the people that are directly affected. So you will be affected. So if your husband is already here, or your wife, the F1 principal is already here, then it's probably just going to extend the period of your separation. But if your F1 principal is also outside the United States, the only thing you can do is to contact the school and request that they defer your admission. That's the only thing you can do. But will you be affected? Yes, you are. Next question, please. Hello, doctor. Merry Christmas in advance. Sir, does the USCIS only accept government-issued death certificate or a private hospital death certificate issued will be accepted as part of an evidence in a case where a death certificate is required? Well, it depends on the country you are talking about, because what USCIS do is that they rely on the information provided by the Department of State reciprocity information. If you are talking about a country like Nigeria, they will not accept a death certificate issued by an hospital. They will accept a death certificate issued by the National Population Commission. So what you need to do is to take the death certificate that was issued by the hospital to the National Population Commission and then request a death certificate. That is what they will accept if you are from Nigeria. If you are not from Nigeria, it depends on the information provided on the Department of State reciprocity information, which is what USCIS uses. Next question. I already have my USA B1, B2 visa since 2024, which is valid until October 2027. I have not yet traveled to the USA since I got my visa. I have a passport from the Republic of Benin. So what's the question? Okay, which is one of the countries affected by the partial ban country designation? Will I be affected by this if I travel to the USA after January 1, 2026? No, you will not be affected because you already have your visa. You will not be affected, except your visa is revoked. So just watch out. Before you travel, just watch out your email. Make sure you check your email before you head to the airport to be sure that your visa has not been revoked. But are you affected? No, you are not.
And this was a follow-up. Somebody posed a question.
Okay, Dr. Asekun, thanks a million to you and your fabulous team. Thank you. We are blessed with you. Thank you. Thank you. We appreciate it too. Is there a B part to that one from Benin Republic? I thought
No,
that's for
it's
another
the same
person.
thing again.
Oh, okay, okay,
Yeah, they posted it twice.
okay.
Okay, now we answered. Okay, there.
Okay, next question. Are I-140 petitions for people inside the USA on pause? No, it is not. It is not on pause. Next question. Merry Christmas, sir. If I have NTA with pending VAWA case, what are my options? Well, it depends on the court where your case is assigned, because some of these judges are different. Some judges, if you have a pending VAWA, they will give you a continuance and allow USCIS to adjudicate your VAWA. But some judges, they will tell you they cannot wait, that you should submit your VAWA application in court, because the immigration court, they also have the authority to adjudicate a VAWA petition. The only problem is that with the immigration judges, your VAWA has to be really strong, because now you will have a lawyer antagonizing you in court. You will have a lawyer who will be pointing out all the deficiencies in your case, who will be telling the immigration judge to deny your case, whereas you don't have this antagonistic position with USCIS. which is why it is better for USCIS to be the one adjudicating it. But some judges will tell you file your VAWA in court, so they will adjudicate it. So either way, just make sure that your VAWA is very strong. But I will prefer that USCIS be the one to adjudicate the VAWA, because they are not, you will not be faced with an antagonistic position at that level. Next question. Compliment to you and the team. You're welcome. Merry Christmas. My L2S I-94 expire in few days, but I filed I-485 and I-765 in June 2025 and still waiting for decision. Can I work with auto extension of I-765 while I wait for approval? Yes, that is actually the purpose. Yes, you can work. Next question. Merry Christmas to you and your team. Merry Christmas. Is it true that all pending applications have been... No, I think we have answered that.
Yeah, we've answered.
No, there is no such thing. That is not true. Next one. Good day, sir. I was scheduled for oath swearing and appointment was cancelled. I travel out. Should I come back before the ban takes effect? It doesn't affect you. If you are talking about naturalization, that means you have green card. So the ban does not affect you. So take your time. Okay, somebody said we cannot hear you. Maybe that's the person that called the office. Okay. Okay. Yeah, I even increased the volume. I can even hear myself. It's so loud. So I believe everybody should be able to hear me clearly. Okay. Next one. Merry Christmas, sir, and to the team. Merry Christmas.
Merry Christmas.
Please, I sent an email about EB2, but no response yet. Thank you.
I'll look into it.
Okay, we'll look into it. We'll look into it and respond. Next question. I was told by USCIS online call that I-589 cannot be added to an online account. Well, if it was a paper filing, yes, but if you file it electronically in the first place, you have online accounts. I mean, we have a lot of people who do have online accounts. But if your application has been pending for a long time and you file it by paper filing, the reason it will not be added to online account is that your file is not available online. So even if they allow you to add it, you will not be able to see anything. So that's why they don't add paper filing to online account. But if your application was e-filed, yes, you can have online account. Okay.
Oh, you answered this one.
Compliment to you and the
You already
team.
answered it.
Thank you.
Yeah, you answered that.
Okay, yeah. Hello, sir.
Sorry, it keeps moving.
Can someone apply for non-military medical deferred action to USCIS while the person has an upcoming master calendar hearing removal proceedings, or do you attend your hearing first? Well, somebody who is already in removal proceedings cannot even apply for... Anyway, you can still apply. You can do it. They are two independent things. They are not the same. You can apply even while you are in removal proceedings. You can still do it. They are two separate things. One does not affect the other. When one does affect the other, if you are granted the deferred action, then you can tell the judge that you have been granted deferred action and the case could be terminated. You can also request a deferred action while you are in court, but you have to request from the DHS, not the immigration judge, because it's a discretionary thing. The judge cannot grant you that. It is the DHS that brought you to court that can grant it to you. Next question. Good day, sir. Happy holidays. I wish you the same. Merry Christmas. Please, do you know how long it takes to get an appeal hearing for an asylum case? Appeal, is this person talking about BIA or is it a referral? Well, it's not very clear.
It would be a referral. I mean,
It's not. If it's a referral, they will put a date on the notice to appear. So maybe it's an appeal with the BIA. Well, if it's an appeal with the BIA, right now, appeal is taking a lot of time. One thing I can tell you, there is only one Board of Immigration Appeal that covers the entire United States, and they are in, I think, is it Vermont or Virginia, the BIA office?
It's in Falls Church,
Virginia, yeah, is in Virginia. There is only one BIA office. So cases are taking much longer. And I remember at the beginning of this year, when this administration came into place, they even sacked some of the BIA judges. They reduced them, I think from 25 to 12 or something. They reduced them. So definitely there is no way there will not be backlog. I can tell you we have appeals that have been pending for more than 2 years now. Even before Trump came into office, we have appeals that have been pending. So it's something that takes time. But the good thing is, if your case is an asylum, you still have the opportunity to renew your work authorization while your appeal is pending. Next question. Complement of the season, sir. What about a green card that has been approved under VAWA since 2025? January 2025 January be affected when filing for naturalization in the year 2028 with these new policies? Well, if the policy stands, yes, because the policy says that all those confidentiality will end at naturalization. Yes, it will affect you. But since you already have your green card, I will advise you still have about at least less than 3 years, so you can still put your house in order. If there are things of concern, you can still clear everything. And more importantly, you already have green card. Even if, worst case scenario, even if there is an issue, for people who already have green card, they stand a better chance of remaining in this country legally than people who don't have green card. There are some special waivers that somebody with a green card can still apply for, but which are not available for people who don't have green card. But at the end of the day, we don't even know what will happen between now and 2028. It's still a long time. But under the policy, yes, the confidentiality ends at naturalization. That is what the policy says. Next question. Oh, somebody said something about the sound. Maybe.
Yeah, no,
Okay, yeah, he said the sound went off. Okay,
the sound went off
for some few minutes. Oh, okay.
I stopped hearing you, but I can now. We can hear you. We can hear you now.
Okay.
What?
At least every
What's that?
Dr. Asekun, I discovered you from Daddy Freeze Live. I don't know who Daddy. Oh, Daddy Freeze. I think that's a Nigerian. Well,
We'll have to look it up.
well, thank you for the information. That's all I can say. Thank you. Compliment of the season. Thank you. I wish you the same compliment of the season. I'm trying to remember who Daddy Freeze is. I think, yeah, I know he's a Nigerian, but I'm trying to remember whether he's a musician or one of the bloggers. I don't. By the name rings a bell. Daddy Freeze. The name rings a bell. Okay, let me go ahead while you do that research. Thank you for all you do, sir. You're welcome. My 5 years R1 expired in April 2026. I applied for EB1A and got approved. We have submitted our AOS. How do I expedite our 765 for me, wife, maybe, and children?
My son.
Did you see that? I didn't see.
Yeah. Okay.
Oh, okay. How do I expedite my I-765 for me, my wife, and my son? At the moment, we need help financially. We submitted our AOS in October 2025. Well, if you submitted the application for employment authorization in 2025 October, this is December, that's probably about 3 months, November, in fact, 2 months. So it's still really within processing time. No, first and foremost, since your R1 has not expired, you can still continue to work for the religious employer. Secondly, what you can do for your wife and for your son is to request for expedited processing of your employment authorization, and you can send in requesting expedited processing, complete a very detailed um, affidavit explaining the financial hardship that you are going through. You can request expedited processing of your employment authorization, because employment authorization based on the information you provided is still within processing time, but you can submit a very detailed explanation as to your financial needs. The only thing I want to tell you, you have to be careful. This is EB1A. This is employment-based petition. You want to be careful. You don't contradict the information you provided on your EB1 petition, because if you are claiming, because EB1A requires you to be an alien of extraordinary ability, you are supposed to be among the top in your profession. You are supposed to be among the top 5% in your profession. If you claim all of these things, and now you are also claiming on the other hand that you are struggling financially, that may contradict each other. So I will advise you against it, even though it's a possibility. It is something that is possible, but you have to be careful about contradicting whatever information you have provided in getting your EB1A, because EB1A is an alien of extraordinary ability, and it requires you to prove that you are among the top 5% in your profession. So if you prove that successfully, and now in the same vein, while still applying to the same USCIS, you are now saying on the other hand that, you know what, I can't even feed my family, we need this urgently. That may be a problem. So you want to think twice. But is there a solution? Yes, it is possible, but you have to think twice before you apply the solution, so that it doesn't come back to haunt you.
Daddy Freeze Live is a Nigerian Romanian broadcaster, media personality, co-host of the Honest Bunch podcast. He's also the leader of an online ministry called the Free Nation Church.
Okay. Yeah, I remember him. Yes.
Okay.
I remember Daddy Freeze. Yes.
Okay.
I remember him. Well, shout out to Daddy Freeze. Yeah, shout out to Daddy Freeze. I remember him. I think I remember him. Okay, so next question. Good day, sir, and thank you for all you are doing. Please, are there any updates regarding T visa application and a timeline? Thank you. I'm not aware of any update regarding T visa. T visa is the victim of trafficking. That is victim of trafficking. If you are a victim of human trafficking, that's when you apply for T visa. I'm not aware of anything recently that any recent update regarding T visa. No. Even though we will specifically check now that we mentioned T visa, we will specifically check, but I can't think of any update regarding T visa. So let's go to the next question. Next question. I'm a VAWA approved permanent PM. I want to assume is permanent.
I think.
I have issues with some of these abbreviations because some of them misuse all the terminologies in immigration, so I don't want to give it wrong interpretation. Okay, I'm a VAWA approved, I want to say permanent resident with my sons as derivative, and I had my 10-year green card. Okay, yeah, it's permanent resident, so it should be PR, not PM. Okay, and had my 10-year green card, and my son also have an SIJ application approved. Do you think I should apply for AOS, a faster green card for my son, as he can't apply for AOS? I have a lot of issues with this question because if your son is an SIJ applicant, SIJ is supposed to be for children who cannot be reunited with their children because they have been abused or neglected, or it is not in their best interest to be returned to their parents. So if you as the parent, you are now trying to apply for green card for the same child that is not supposed to be reunited with you. So I have a lot of issues with that question. So I really don't know how to answer this because there are contradictory information here. Maybe there are more facts that you need to give to us, because if you are a green card holder and your son has an approved SIJ petition, the question I want to ask is, who is the SIJ petitioner? Who filed the SIJ on behalf of your son? Because it cannot be you. Because for SIJ to be granted, you need a district court here in the United States to make a determination that it is not in the best interest of that child to be reunited with the parent, either because the parents have neglected or they are abusing that child. So if you are the parent and you are not the petitioner, so how come you are now bringing back the child to apply for green card for him after somebody else filed an SIJ, after somebody else went to a district court here in the United States and presented evidence that this child, it is not in the best interest of this child to be reunited with the parents? You know that this can even lead to criminal offense. So I think you need to see a lawyer one-on-one. I would recommend that you need to see a lawyer one-on-one so that you don't complicate things. This is not the kind of question I can just tell you yes or no, because these are two facts that contradict each other. Let's go to the next question. Hello, doctor. Please, can you handle my case? I won the DV lottery. I'm a J1 teacher subjected to the 212E. Unfortunately, my no objection waiver was denied. Please, what can I do to benefit from the DV? That would be tough. I don't want to give you false hope, because you have two issues that are not friendly. The 212E requires you to return to your home country for 2 years. 2 years foreign residence requirement. That's a mandatory provision. And you have also indicated that they deny your no objection waiver, which means that they are insisting that you have to go back to your home country and stay there for 2 years before you can come back here. And DV lottery is something that is only available within 1 year. And I know that the current DV lottery applicant, their applications has to be processed by September 30th, 2026. So I don't see how you can take advantage of this lottery. But what I will do, can you get that person's information? Let me research into it after Christmas, because like I said, we are already on Christmas break. We just came in here for the purpose of the podcast today. And that is why we are taking our time, because we are after Christmas. I will look into it and see if there is any way out. But as I'm sitting right here, right now, addressing this thing, I cannot think of anything. But I don't want to rule it out. Let me do more research and see if there is any way out. That's what I can say, but it's going to be a tough one. Okay, Hello, sir. I currently have a 10-year green card expiring June 2026. I plan to travel to Nigeria in February. Am I good? Oh, yes, for as long as you don't have criminal record, you are good. For as long as you don't have criminal record, you can travel. Yeah, he can still use the green card up to June 2026, but you can also apply to renew your green card before you go or after, because if your green card is expiring June 2026, you can actually apply for renewal right now. You are allowed to apply for renewal up to 6 months before expiration. So you can apply for renewal right now, but you can also use it to travel and come back before June. Yes, you can travel without criminal record. Next question. If a 48-month green card extension holder that will expire in 2026 then file for naturalization, will the partial ban affect this, and what can the person do if they don't receive a response? First and foremost, we have explained several times the partial ban does not affect people who are in the United States and they are living in the United States. It only affects people who are applying for visa at the embassy. So the partial ban or full ban does not affect you. Next question. I thought there's a next one to that one.
There was just somebody saying thank you for answering a question.
Oh, okay. Oh, okay. It's just a thank you for answering my question. Okay, you're welcome. Thank you too. Merry Christmas. So next one. Okay. Hello, sir. Thank you for all you do. You're welcome. Can you expedite for a stepchild who is documentarily complete under this current ban? Ban affect visa appointment schedule for the same stepchild of a U.S. citizen. Unfortunately, if you are applying for visa, the ban affects you. So there is nothing you can expedite. The expedite will have been before 31st January 2026. Well, let me not say it is not possible. Today is still 24. But there is holiday on Friday.
Yeah.
But there will be work on Monday, Tuesday. When is the first? I think first is Thursday.
Yeah.
So there will be work on Monday, Tuesday. I don't know.
Well,
I don't know about Wednesday, even though it may not be a public holiday, but a lot of things may not work that day. To expedite before 31st will be a tough one. But I will still give it a chance. Who knows? Maybe you talk to your congressman. Go and use congressional intervention. As a U.S. citizen, look for the congressman representing your district. If your congressman is a Republican, go and talk to him. Go and talk to your congressman. Tell them you are a U.S. citizen. Tell them you are one of his or her supporters. Tell them you are desperate to bring your children here. Tell them that your children are already scheduled at the embassy. Tell them about the travel ban. Tell them you need help. But if your congressman is not a Republican, look for your state senator. Because I can tell you, I don't know if this is something I should be saying online, but I can tell you that Republican congressmen are more effective under this administration. That is a trend that I've noticed. But after from January 1st, yes, your son will be affected. So there is really nothing that I can think of that expedite it other than congressional intervention. Okay, we've been on this for 2 hours now, but let's see.
Answer 2 more questions.
Okay, let's see the next one. Sir, for someone who have gotten letter from NVC from immigration, can such person continue to pursue their approval? Oh yes. If you have an immigrant visa and your case is from the NVC, yes, continue to process. The travel ban is going to be reviewed in 180 days time. It's going to be reviewed in 6 months time. So you still have to deal with the NVC. NVC process sometimes can take time. Your beneficiary will still need to go and obtain a police clearance certificate from every country that they have lived since I think they reduced it to age 14 now. It used to be age 16 before. So you will still need all of that. Yeah, continue it. Even we have cases, despite the fact that we are lawyers, we still have cases that have been documentarily qualified for more than 6 months and we have not received interview notice. So continue to process it. So you are still a long way to go. So don't stop. Continue processing it. That would be my recommendation. Next question. Okay, this will be the last question for today. Like I said, our office is already closed. We are just here today just for the purpose of this podcast. So the last question will be, okay, USCIS has memo saying applicant country of concern is a significant negative factor. Do you think USCIS will use RFE asking people from bank countries to submit positive discretionary factors? I think I've answered this. These affect people that are applying from outside. So it depends on the application that you have pending. But again, I don't see how the status of your country, for example, will affect an application that you file that is based on marriage to a U.S. citizen. I don't see how your country being designated a country of significant concern will affect an application that you file that was filed on your behalf by your employer. The only area where I see USCIS where I see the U.S. government designation of a country as a country of particular concern will be areas where USCIS will need to use a discretion in your favor. Yes, that may be a concern, but generally it will be a plus for people who are applying for asylum. Again, we are going to be stopping here today. We have been on this now for 2 hours. We are going to be stopping here today. I want to wish all our viewers Happy New Year. Anyway, Merry Christmas, because we will still see you before the end of the year. By God's grace, if God tarries, we will be here again next week, Wednesday, to see you, and that will probably be the podcast of the year. Before we go, let me ask you, when do we announce the free consultation?
Next week.
Okay, so we also want to let you know that next week will be the final podcast of the year 2025. Next week will also be the time that we'll be announcing the free consultation. So please bear that in mind. Until then, I want to advise you, please stay calm, stay out of trouble, this is a Christmas season, avoid drinking and driving, avoid anything that can bring you to the attention of ICE, avoid anything that I will not do. I wish you Merry Christmas and
Merry Christmas.
Greetings from our team. These are the only two of us that are here today. But even next week, it will still be me and you next week. Okay. We hope to see you again next week. Until then, remember to follow us on all our platforms, Instagram, TikTok, Facebook, X, what else? And YouTube. See you again next week. God bless you. Have a wonderful Christmas.